every one of those objects was found in Miss Ryder's tent.
That is correct.
Now, only having those 3 items, you still decided that this was Miss Ryder's hiking stick.
When I had met with Detective Chesney, he had told me where these pieces of evidence came from. He gave me some information about them.
Yeah, you don't have any DNA evidence linking Miss Ryder to the hiking stick?
I didn't test for DNA evidence. I tested to see if any of the items could have caused injuries on Miss Gage's body.
Dr. Quincy, you're in court today because the state's trying to convict someone of murder.
Yes, that is correct.
You didn't think it was useful to test for DNA evidence on the hiking stick?
No, my primary focus was trying to figure out what happened to Miss Gage that night. And I was testing to see if any of the objects could have caused those bruises.
You never looked for fingerprint evidence on the hiking stick?
No, I did not.
In fact, the only reason that you concluded the hiking stick was the murder weapon was because of the measurements.
That is not the only reason. The hiking stick was also a perfect half circle shape, and that matched the shape of the bruise as well.
Right, Dr. Quincy. The measurements of the bruise and the hiking stick matched up. That was your only conclusion for the hiking stick being the murder weapon.
That was enough to lead me to believe that the hiking stick was the cause of that bruise.
Dr. Quincy. Dr. Quincy, before trial today, I found some items that also matched the hiking stick and the dimensions.
Objection, Your Honor. Lacks foundation.
Counsel?
I'd ask the opposing counsel explain their objection for what lacks foundation.
Yes, Your Honor. We don't know who collected this evidence, where it came from, and how it can be administered today in court without this foundation. And we have a good faith basis that opposing counsel cannot lay where this came from and how it can be considered evidence. It cannot be testified today in court.
Response, Your Honor.
Yes.
Your Honor, I just testified that all these items were picked up by me before trial today. If I may proffer to why we're going to use these items.
I don't think that's the issue right now as far as why you're going to use it. I think the question right now goes to foundation. Do you have any response as to the foundation part?
Your Honor, it doesn't really matter where these items came from. What we're showing is that Detective Chesney never gathered any other items from anywhere else other than Miss Ryder's tent. These items could be found anywhere, and that's exactly the point. The murder weapon could be anything. Therefore, there's foundation for this.
May I respond, Your Honor?
Yes.
It of course matters where these items came from. If this witness is going to testify if other things are potential murder weapons, then of course it matters who collected them, what chains of custody, and opposing counsel cannot bring random objects they found anywhere, as they have just stated, and expect this witness to testify and potentially make a conclusion that is a potential murder weapon.
Last response, Your Honor.
Yes.
The point of this demonstrative is to show that the only reason that they concluded the murder weapon was hiking stick was because of the dimensions. If there are any other items that also match the dimensions, that could also be the murder weapon in today's case.
The motion sustained if there is foundational information as to, for example, it being somewhere near the incident, I would allow you to reopen for that, but that is sustained.
Yes, Your Honor.
Motion to strike, Your Honor.
Granted.
Now, Dr. Quincy, if any other item had a 2.25 centimeter diameter, could that be the murder weapon?
Well, I would have to conduct additional tests to determine that.
Now let's talk about those additional tests. Detective Chesney also brought you pictures from the campsites.
Yes.
And you ruled out murder weapons from all those pictures.
I didn't rule out murder weapons. I was able to take a look at them, examine them, see if there was potential that there could be other items as well.
You never ran measurements on those items?
No, they were just photographs.
Exactly. You only had pictures to rule out potential murder weapons.
I had photographs of where Miss Gage's body was found. There wasn't anything specific that I could ask for or ask to get so I could conduct measurements.
Dr. Quincy, could you rule out murder weapons by sight?
No, of course not.
But you ruled out these murder weapons based off sight in the pictures.
They were photographs of where Parker's body was found. It was not of specific items that I could make conclusions on about whether or not they were murder weapons.
All right, Dr. Quincy, before trial, I made impressions in this clay. And one of them is this murder weapon. Could you point it out to me?
Objection, Your Honor. Lacks foundation.
What's your question again? Would you restate your question?
Yes. Dr. Quincy, before trial I found imprints in this clay. One of them is the murder weapon. Could you point out which one the murder weapon is?
If I may respond, Your Honor,
Yes.
opposing counsel did not see this counsel did not see opposing counsel create these indentations, and therefore it cannot be used today in trial.
Response, Your Honor?
Yes.
That's exactly the point. The only reason this demonstrative works is because Dr. Quincy doesn't know which one the murder weapon was used to make. This is able to pull out logical fallacies in her conclusions and ruling out a slew of murder weapons based off pictures alone.
If I may respond, Your Honor,
Yes.
there's a difference between showing this counsel a witness or a demonstrative that is going to be used in trial versus showing the witness. This counsel has a right to know all demonstratives that will be used and has a right to prepare a potential rebuttal. Because we did not have that opportunity, this demonstrative cannot be used today in court.
Let me inquire first. Is your objection that you didn't see it early enough to do some investigation, or that there's no foundation or some other reason that this cannot be used?
The first one, Your Honor, that we were not shown and therefore cannot rebut it if needed.
Your Honor, during captain's meeting, we did show them this captain's meeting before trial. We did show them this demonstrative.
If I may, Your Honor.
Yes.
When this was shown during pretrial, there were no indentations made within the clay, and therefore the creations were made right before trial, and we have not seen them.
Is that correct?
That is correct, Your Honor, but this demonstrative shows that Dr. Quincy can't rule out items by sight alone.
The motion is sustained.
Move to strike, Your Honor.
Granted.
Dr. Quincy, you have no DNA evidence linking Miss Ryder to that hiking stick.
No, I didn't.
Point of order, Your Honor, there is a stipulation that says that both parties have agreed to, it is stipulation 14, saying that the Midlands Crime Center lab tested Exhibit 17 and other
Speak a little slower.
excuse me, Your Honor.
That's okay, go ahead.
The Midland Center Crime Lab tested Exhibit 17 and Parker Page's cell phone for fingerprints. No usable fingerprints were found on either item. So this line of questioning Dr. Quincy, has already been stipulated and both parties agree, therefore this line of questioning is not needed.
Is it, just for clarification, is the stipulation in that somebody else did the investigation and not Dr. Quincy?
Yes, Your Honor.
Response, Your Honor.
Sure.
The stipulation only applies to fingerprints. Dr. Quincy can attest that neither fingerprints were found on this hiking stick from Jordan Ryder or Parker Page, and also that no DNA or further tests were run after these fingerprints analysis were conclusive.
So there's a stipulation that fingerprint analysis was done by the police department or something of that nature, and now you're asking Dr. Quincy whether she also did? Is that right?
We're asking about DNA evidence and whether she read any DNA evidence from Parker Page's body or the hiking stick to conclude that this was the murder weapon.
If I may respond, Your Honor.
Sure.
DNA evidence includes fingerprints. Dr. Quincy was not the one who was responsible for conducting these tests, therefore she would have no knowledge about the potential DNA evidence that was found.
So what is your objection?
The objection is that this line of questioning is irrelevant, Your Honor.
Response, Your Honor. Dr. Quincy is the chief medical examiner. She views crime scenes and murder weapons all the time. It is her job to run DNA evidence on the victim's body and the murder weapon to see if there's any link.
Have you determined that foundationally from her? If you ask that foundational question, you might be allowed to ask the follow-up questions.
Yes, Your Honor.
Go ahead.
Dr. Quincy, did you collect DNA evidence from Parker's body?
No, I didn't.
Dr. Quincy, did you collect DNA evidence from the murder weapon?
There was no DNA evidence to collect from the murder weapon. I was informed that there were no fingerprints. There didn't seem to be any hair strands or anything else that I could take a look at from the hiking staff.
Dr. Quincy, did you look for any potential DNA on the alleged murder weapon?
Counsel, the question for foundation is whether that is her job to do that, not whether she did it initially, for me to rule on the prosecution's objection.
Yes, Your Honor. Dr. Quincy, is it your job to look for any DNA on the alleged murder weapon?
No, I am the medical examiner. I conduct autopsies on bodies and make conclusions on the bodies. I do handle evidence, but it's not my job to verify them or clear them of anything.
Now, Dr. Quincy, I want to talk about when you came to your conclusions in today's case. You went to the crime scene.
Yes, I did.
You checked your analysis.
My analysis of,
Parker Page's body.
What, I'm sorry, what's the question?
You analyzed Parker Page's body,
I did. I conducted an autopsy on Miss Page.
and you submitted your initial report on July 16th.
Yes, I did.
And that report ruled that Parker Page's death might have been accidental.
My report ruled that Miss Page's death could have been accidental or homicidal. It was only after I received additional evidence and information on the case that I was able to conclude that it was a homicide.
Right, Dr. Quincy, you met with Detective Chesney on the 19th.
Yes, I did.
And it was only then that you changed your conclusion to a homicide?
No, I changed my conclusion and was able to rule it a homicide after I tested the additional evidence and further analyzed it.
Right, Dr. Quincy, after your meeting with Detective Chesney.
After I conducted my tests in my research lab and verified that these items matched the bruise on Miss Page's body, I was able to conclude that her death was a homicide.
No further questions.